Hello and welcome back to our podcast, What Now? On the Threshold of Life, Death, and Grief. And we're back in the studio. And as usual, I am here with my friends and colleagues.
Red Keating.
And Dave Kennedy.
And I'm Julie Brown.
Thanks, Julie. And today I'm just delighted to introduce a wonderful guest that we have with us today. And I've been looking forward to this one, Mr. Bill Lockington. And Bill, let me just introduce you a little bit and just to tell you how thankful we are that you have agreed to join us tonight. Bill is a founding partner of LLF law firm here in Peterborough and provides his clients with the benefit of over 40 years of legal experience. And his practice focuses on wills and estates and wealth management, succession planning, business law. Bill holds a certificate in advanced alternative dispute resolution. He provides mediation services to small business owners in dispute and family members hoping to resolve acrimonious estate matters. I want to move a little bit from, and you have so many wonderful professional pieces here, Bill, and it would take me 5 minutes to get through them all. I want to pay tribute and honor to what a wonderful contribution you have made to our city and community of Peterborough. Bill has been so active in so many different ways. He's on the in the Rotary Club. He's received the Paul Harris Fellowship. He's been Peterborough's Business Citizen of the Year in 2011, or 2009, pardon me. He has been a board member and chair of the Community Foundations of Canada and a board member and founding chair of the Community Foundations of Greater Peterborough. Bill has sat on so many different boards, the Canadian Canoe Museum and Hospice, which is where we really connected and got a chance to spend time together. And I would just like to acknowledge that in all of these, my experience with Bill has been one of someone who is just gracious in his time and very generous in all of his activities. And you really have made this community much better because of your involvement. On a personal level, Bill is a great and avid photographer, and in fact was the co-founder and board member of the Spark Photo Festival here in Peterborough. And Bill has done some amazing photography, and I just imagine that's a real kind of an outlet for you after all of the legal pieces in your life. So we are just so delighted that you've agreed to help us tonight in this podcast and just kind of help our listeners understand this very, very important challenge of finding our way through all of these important pieces as it comes to dying and death and grief. So thank you, Bill, for being here.
I'm glad to be here. And jumping off of that, Bill, I mean, we see this all the time in our own practices. This is a quagmire of information and misinformation, and people often are lost and don't know where to even start when it comes to issues of power of attorney, writing wills. They're, I think emotionally difficult documents to think about writing. And so sometimes we avoid them, which then makes them mysterious and maybe more complicated and scary than they need to be. So if someone were coming to you, people are listening to this, what would be the first thing you would say to them about the importance of a power of attorney and a will and what they actually are?
Well, that's a good term, quagmire. In my perspective, it's maybe not as complicated, but to someone who has never done a power of attorney, hasn't done a will, or been on the other side, they haven't acted as a power of attorney for someone, or they haven't been an executor of a will. Any of those roles are very daunting to people who haven't experienced it. So typically, when I meet with people who are wishing to do their what I call testamentary planning, we try to outline what some of the key building blocks are to doing that. And one of the things that I find is a significant misunderstanding is what exactly is a power of attorney and what exactly is a will, and how do they fit together? Are they the same people? Are they not the same people? Are the roles the same? How does it fit together? And so what I do, and I try to do it graphically most often, it's easiest to describe on a piece of paper with some lines and things
Right.
and circles, and draw a typical family and do it that way. But there is a dividing line between wills and powers of attorney. So that dividing line is really important in understanding both the function and the roles and the responsibilities. A will, I make a will to dispose of and allocate, distribute my assets, basically. That's the principal function of making a will. A will is a testamentary instrument. When I make it, I generally appoint someone who will be, the term most commonly used is executor, but they have a fancy new name now called estate trustee. So if I use the term executor and estate trustee, and are treated as interchangeable for our purposes. So I appoint one or more people to be my estate trustees, my executors. And that will sits there. It talks about what I would like done with my assets. It expresses my philanthropy if I'm interested in that. It acknowledges people who have been part of my life train, and essentially disposes of my assets as we go. Now, that will doesn't mean anything until I die. All right. So even though I've made a will, my estate trustee has no authority to act on my behalf with respect to any of my financial affairs or anything until I die. The minute I die, my will speaks. And at that point in time, the estate trustee or executor becomes empowered to deal with my assets. A power of attorney, and I might add, it has nothing to do with lawyers. It's a question we get asked quite frequently, and then I have had people say, "Well, aren't you my power of attorney? You're my lawyer. Aren't you an attorney?" And I said, "No. Power of attorney is a term that is used to describe the role of an agent. So people who I appoint as power of attorney for me are really agents. They act for me, but they only act for me when I'm alive. And the key is that the moment I die, anyone that I have appointed as a power of attorney, that power of attorney and authority is automatically canceled. So you can't be the same person acting as a power of attorney and an estate trustee at the same time. They bump up against one another just for that instant in time, but they can't be the same person. When we do a power of attorney, there are two types of powers of attorney. One's called a power of attorney for property. And again, they've used the term property, and everybody thinks, well, that's real estate. Well, it could be real estate, but it's not always real estate. A power of attorney for property deals with my financial affairs, my assets. It would let someone contract for me, enter into a lease, anything of a commercial nature or dealing with my assets. So that power of attorney, quite often the person who is my estate trustee over on the other side is also my power of attorney for property, because the functions are somewhat similar. They're dealing with assets and management of affairs, that type of thing. The second power of attorney, and this was new in 1992 when the legislation was first created. So 1992, the Ontario legislature created this role of a power of attorney for personal care. And a power of attorney for personal care is a delegation of authority to someone to make decisions on my behalf only when I'm not able to make them. All right? I have to be incapable of making an informed decision before my power of attorney for personal care has authority. And I often use the example of the nature of a power of attorney for personal care because sometimes it's difficult to understand. But if I was in the hospital undergoing a procedure, for example, and I'm anesthetized, I'm on the table and I'm unconscious, when I'm incapable of making a decision, my power of attorney for personal care could do it. So to take the example, the surgeon says, Well, we fixed that, but look at this. We need to do this as well. But they don't have consent to do that. So they out to the waiting room, find the power of attorney for personal care. Bill can't decide, but we recommend to do this. We need the consent of the personal care power of attorney to do it. So they do that. The other thing that's interesting about a power of attorney for personal care is that that authority can float. So I'm not very good under anesthetic. So for 3 or 4 days after an operation, I might not be lucid at all. And during that time, even though I'm conscious, my power of attorney would have authority to make decisions. On the 5th day, if I come out of that and I'm back to normal, they no longer have authority. So it floats. It can go up and down, which a lot of people wouldn't understand.
Would that be the same for your power of attorney for property?
No.
Okay.
The power of attorney for property, in most cases, becomes effective the day you sign it, and it's in effect the day you sign it. Now that's the current practice. 10 years ago, most powers of attorney for property would not become effective until there'd been a letter from a doctor stating that they were incapable, that type of thing. But the better practice, we never know when a power of attorney for property is necessary. I could be traveling in Europe and selling a house in Ontario and need my power of attorney to act on my behalf. I'm perfectly capable, I'm just not available. So that power of attorney generally becomes effective the day you sign it. It's a document of emergency, really, and what we generally do is we would store the originals away with a person's will, only to be brought out when it's needed, because it is a document of authority and people can abuse that authority. So that's how we control that. You can also make that power of attorney for property conditional on certain things. They don't have to be a general, all-encompassing. But if it's unconditional, then the person who holds the power of attorney can do anything that I can do except make a will. So an unconditional, continuing power of attorney gives that authority. But you could restrict that. You could say this power of attorney is good only for the purchase of my Mustang convertible, and it would be strictly restricted to anything that was involved with that. So when I say a general power of attorney that is general in nature, most often it is, but doesn't need to be as far as that's concerned. I don't know whether that explains the differential, but quite simply, powers of attorney are delegation of authority to an agent while I'm alive, and they can act while I'm alive. But the moment that I'm deceased, they're canceled, and my will speaks from that moment on. And that is once people understand that, it's a lot easier to discuss who those people should be that I appoint, and what scope should I give them.
I think that's such good information because people hear that power of attorney and they go one of two ways. Either both of those operate the same, only when the person is incapacitated, or they don't appreciate how those two operate differently. I was going to ask you, Bill, so this is a provincial legislation that regulates this. How many other provinces in Canada have similar type of restrictions in that? Are you aware of that?
Yeah, almost all of them.
Okay.
Yeah, it's in Ontario. This legislation is under what's called the Substitute Decisions Act. So that's the act that governs powers of attorney, guardians of property. It deals with the whole spectrum of acting for other people. So even if you don't have powers of attorney, it sets out the procedures whereby you could be appointed by the courts as a guardian of the person or the guardian of property. The terms are different, but it's the same type of thing. But with a power of attorney, of course, you do that voluntarily. You create the scenario. If there isn't a power of attorney and someone has to apply to the courts to be appointed as a guardian of property or guardian of the person, it's time consuming, it's very expensive, it might take 6 to 8 months to get it through the courts. You're dealing with the public guardian and trustee in many cases, the office of the children's lawyer. It's cumbersome and quite often does not meet the timeliness of the requirements.
Is it possible to clarify? Because I quite often hear people being confused. They hear the term power of attorney, but they also hear this other term, substitute decision maker. And is there a difference, or are they interchangeable?
Well, a substitute decision maker is a power of attorney, but a substitute decision maker could also be a guardian of property appointed by the court. So a substitute decision maker is, in the broadest sense, the person who can make decisions for other people. A power of attorney is the vehicle, if you will, by which a substitute decision maker makes those decisions. That's the difference.
Nice distinction.
Yeah.
Bill, I'm wondering about the kind of advice you give families when they're having to make the decision around who do I give this delegation to? Because sometimes I've heard families say, well, that should go to my oldest child, or, like sometimes there's these family norms or traditions, but that doesn't necessarily mean that's the best person for that. And I'm just wondering what you offer for guidance around that decision.
Well, it's a real balancing act, because most parents don't want to offend any of their children. That's, if we don't have to do that, that's good. So if we have 4 children, and to not offend anybody, let's appoint them all. That, in many cases, can be a recipe for disaster. And the question I ask everyone who's appointing a family member or members as a power of attorney or an executor is, I always ask the question, how do they get along? What's their relationship? All right, because that's absolutely critical to understanding how the role of power of attorney or executor, either one, is going to be carried out. And if there's fisticuffs now, there's going to be fisticuffs later. So determining what the family dynamics are and how it would look, and I quite often ask the table, I say, if you had to sit down with your children at the table now and you put an issue in front of them, what do you think the outcome would be? Would there be consensus? How quickly would the consensus come? Would there be different views? You tell me what it looks like around your kitchen table. And it's very interesting what people will tell you. And when you get to that point where they recognize that, yes, there's going to be difficulty, then they will look at it differently. So what are some of the alternatives to satisfying all of the people all of the time, as who was that said that, anyway, you can't satisfy them all the time. Quite often we'll talk about who's most functionally capable. All right. So if one of my children has no financial experience, expertise, or that type of thing, there'd be no sense, perhaps appointing them on their own as a power of attorney for property, or perhaps an estate trustee executor. At the same time, if I have a child who is perhaps in a difficult personal relationship with a spouse, has exhibited poor judgment in the past, are those considerations that I would look at in selecting someone. Quite often you look at pairings. Are there a couple of your children who are, empathetic to your situation, but they work well together, and you would feel confident with them doing it, even to the exclusion of others? That's the process you go through or part of the process anyway, in trying to determine who should I select, because it is the most important decision. You can empower people with the documentation, but unless you have the right people to implement and exercise the authority that they have, it's all for naught. It is purely the most important decision.
I think one of the the challenges that I've observed, and I've come to appreciate this, and even choosing in my own case, sometimes family members, and we were talking about the health side, that person, because it seems to me we want that person really is there to carry out my wishes. That we hope that they would be the ones to say, okay, this is what Dad wanted. This is what Dad, really was clear about, and I'm here to make sure that gets carried out. But often in families, especially around health, they kind of back down and say, oh, well, I know Dad didn't want to be, put on a ventilator, but I think we should, So often you find there's that emotional pull that sometimes makes it difficult to carry out our own wishes in that. And that seems to be a challenge too with families.
Oh, very much so. It's and again, this is one of those questions that when you're talking about the family dynamics, someone who that would be in favor of one course of action, and another would say, no, that's not what they wanted. Didn't understand that. That's a recipe for disaster. It's always good to think in hypotheticals, and I often think of what's it like at the hospital, at the end of life, and what helps my personal care powers of attorney make the decisions that they may need to make, at that time. So in most of the power of attorney for personal care documents that are written today, there's a broad statement that talks about heroic measures. It's not for everyone, but in very broad sense, most people do not want to be kept alive by artificial means, what are called and known as heroic measures. And I would say, my clients, 95% of people would express that sentiment. So that broad general language is in a power of attorney for personal care. That's an expression of intention. But that's pretty broad, in terms of, so how do you interpret under that? Quite often with a power of attorney for personal care, we can do what's called an advance directive today. Used to be called a living will. And that term is familiar to some people, but it's not. It's the more appropriate term now is advance directive, which is nothing more than an identification of things that I would want done and things that I wouldn't want done. So it expands that yes or no of the term heroic measures in a personal care power of attorney.
Can somebody go against that, though? Can your power of attorney override that, even although you may have said that?
The power of attorney there's a great deal of discretion.
So that's why it's really important to choose the right person there thoughtfully.
And not only choose them, but speak to them.
Speak to them about
and
that,
have conversations about what you want. If in those scenarios that you're talking about, if they were to occur, and of course we can't come up with every scenario that might occur, but you need to give your power of attorney a real sense of truly what it is you would want. And I would think that would come best through having discussions about what you would want with your power of attorney.
Yeah, and that's that hypothetical.
Yeah.
Where you're sitting down and you're chatting about those things and saying, well, if this was the case, here's what I would want. And then expand that. So if you feel that you need to be more explicit in terms of your intention and directions, do an advance directive. Be more specific, attach it to the power of attorney. And that anything you can do that way in terms of communication will be of assistance, believe me. But it's a thing that a lot of people don't do. They don't have that discussion afterwards and talk in hypothetical situations. What would you do?
Mm-hmm.
I'm thinking about that right now as I'm listening, how often I've heard both personally and professionally, like these documents were signed in the lawyer's office, but no conversation was ever had about them. So someone might have known they were a power of attorney, or maybe kind of knew, but didn't really know, but it was never communicated. And I think this is such an important part of what we're talking about, so do the process, the legal process, and then the next step is to start the conversations and to keep those conversations, because also, things change in our life.
Well, it's like the power of attorney for personal care, for example. That's generally needed most often in emergency situations. Has nothing to do with money, so there's no risk, in that document floating around. So our practice when people sign personal care powers of attorney is we put it in an envelope with the child's name, if the child's been appointed, children been appointed. They all get an original copy. So they've got the document. If they have to go to the hospital in an emergency, they've already got it. And that gives them the opportunity to have the discussion with their parents as well. So communication is a big part of this, and the education of doing that. I do have some clients who will convene a family meeting in our office to do just what we're doing now, discussing, end-of-life documentation.
Now, is there a hierarchy? So if somebody doesn't designate a power of attorney for medical, let's say, is there a natural hierarchy that exists?
Well, spouses, yeah, there is.
So
Yeah.
if I didn't have one explicitly made, there is a way of determining
That's right.
who that person would be.
Yeah, there is a hierarchy that hospital staff can go to and receive,
And that goes
instructions.
spouse and then oldest
Children.
child
Yeah.
and then all the way down.
That's right, yeah.
In the example of on the operating table, you're anesthetized, you're unconscious. That's clear. What happens when, let's say, I'm in the early stages of dementia, and I'm still living at home on my own, but the person that I've appointed as power of attorney is afraid for me and concerned, as they, it's honest and they should be. And they want to start wielding some power to keep me safe. And I am resistant. How do those things get resolved? Like what is the role of the power of attorney in that situation, and how much autonomy would I have as an individual in the early stages of a progressive disease that's going to mean I am at some point going to become incapable?
Right. So my experience has been that the shift from being named but not having to help to being completely responsible is a transition. So and I liken it to my father, for example. My father was a well-respected businessman, quite capable into his late 80s. I had been named his power of attorney with my brother probably 10 years prior to that. So the documentation was there. But, at about 88, 89, he said, I think I don't want to go to the bank today. Would you mind going for me? He always loved going to the bank. The tellers loved him, and it was great. But he, just for one reason or another said, would you mind doing this for me? And on a personal care basis, would you mind going to the pharmacy, and doing this? So he started to not relinquish authority or anything else, but it was obvious that he was seeking some assistance in some respects. There were other things that he still did. As that time went on, there is that gradual shift of responsibility and accountability. So you start out here and it's just a document. But over here, so 2 years before his life, I was doing all his banking. He was still making investment decisions 2 years before. And he said to me, you keep an eye on my banking, but keep an eye on my decision making too. So he was still aware enough that he was capable of doing this, but recognized he needed help. The last year before he died, he did start to have some cognitive failure, and we were doing everything at that point. So it's a transition in a lot of cases, right? And people, there is no absolute I'm in charge, you're not type of thing. Although that is one circumstance we see a lot. People don't understand that it is a gradual thing, and in most cases, best practice, you should be working with the person who's given you the power of attorney. It's not a black and white, but you'd be surprised how often People think I'm the power of attorney, I'm doing the whole thing, and no one can question that, you know. And that's really a recipe for disaster. But unfortunately, we see that frequently, you know. So some of the things, you know, in best practice about powers of attorney when we're acting for other people, there are some expectations of how we should act. One of them, or a couple of them anyway, are about communication and collaboration. Advising family members. If I'm the power of attorney, you know, with or without another member of my family, I have an obligation to advise them of the circumstances of our parent, for example, if that's who I'm acting for. I have an obligation to be collaborative, to be informative, to let them know what is going on, and to be communicative. So people will ask me, you know, I've been named as power of attorney, what should I be doing? So if you're the power of attorney for property, I might suggest, well, you know, I would be preparing a financial report for delivery every quarter to the family members. Let them know what the assets are, let them know what the expenses have been, that type of thing. And communicate on that basis. Make sure everyone's aware of what's going on. That's the single biggest downfall of people dealing as powers of attorney for property, is not communicating, not reporting, and not being accountable. And they're accountable not only to the person who gave them the authority, you know, but they're accountable to other family members as well. A lot of people don't understand that there are responsibilities in being a power of attorney to other people. So I often joke about the one when we were talking about selecting the power of attorney. And we had, it's not uncommon, but I often take the situation where I've been in the hospital, I had a stroke, doctor says, Bill can't go home. You know, he needs a level of care that is more demanding than what can be provided at home, and he has to go to, we suggest a long-term care facility. So my power of attorney says, yep, going to the very best there is. That's what Dad wanted. He wanted to be kept in the lap of luxury. The power of attorney for property said, over my dead body. He was frugal. He never spent a penny on himself. This is what he'd want, like this, you know. So I often laugh at that when we were talking about, you know, who you select and what those intentions are. So, because I've had that situation happen more than once, believe me. You know.
Well, and does that come into play too when that dividing line that you talked about, when death happens and the powers of attorney are no longer and it becomes the executor?
Yeah.
What's the other term you used other than executor?
Estate trustee.
Estate trustee. Could people then on the other side who are maybe expecting some inheritance and have some expectations could accuse the power of attorney for property of wasting money or mismanaging money?
Oh yeah, you'd be surprised what happens.
Right.
I say I often use the term when the glue is gone, and the glue are the parents. It never ceases to amaze me when the glue is gone, what comes out of the woodwork in terms of family relations and I don't want to be cynical about it, believe me, but quite often I'm surprised, you know, at what happens. But you know, again, you know, they're somewhat contrary because it's like if you set up a trust for someone in a will, and it's a trust that is to permit a spouse, for example, to live a standard of life to which she'd become accustomed. So living that standard of life may deplete the assets of the estate that the children would receive. So if the children are the executors, you know, you've got this inherent conflict sometimes. So those are some of the things we look for when we're drafting wills.
Do you have any sense of the percentage of people who would choose a non-family member, let's say either for POAs or executors?
Yeah.
And that comes with its own challenges too, I imagine.
It does. It's interesting. Today I was talking to two families, one a husband and wife with no children, and the other one with 3 children but there's very bad dynamics between the 3 children. And in both of those cases, I have suggested that they discuss with and possibly engage a corporate trustee, a corporate estate trustee. All of the banks, so these divisions that the financial institutions have specialize in estate administration. They're not subject to influence. They, have discretion. So it takes away the responsibility, any opportunity for fighting between family. In many respects, it's a service, I think, that a lot of people should consider to avoid, disputes or any affecting of relationships down the road. A similar thing would be with people who are not family members, but maybe respected by the family. They could be a business associate of a parent, people like that. So generally, the perfect combination that we like, if we weren't going to appoint family, would be to possibly appoint a family member with a corporate trustee, do them together, or a non-family member with a corporate trustee. The disadvantage of the corporate trustee is that it doesn't bring the personal aspect to it, the knowledge of the family. What would someone do in a certain situation? So it's always nice to tie someone who has a family relationship with the corporate trustee, and that's quite often a real workable situation. Yeah.
All families are imperfect, and in times of stress, that imperfections, those things can rise, those issues can rise. Yeah. And I can't imagine that those same issues also don't arise after someone dies and someone is enacting a will, and the role of the executor steps forward. So can you explain to us, what is the role of the executor?
So the executor's role, the estate trustee role, is basically to take possession of the assets of the deceased, to liquidate them in many cases, or to distribute them if they've been specifically given to someone in a will. It's to adhere to the terms of the will and carry out the instructions of the person that made the will, to make sure that all taxes are paid, all obligations are looked after. And those would be the principal things in an estate where there's an outright distribution. A will might contain a trust, all right? There might be a disabled child, for example, whose interest would be represented by, or would be managed and administered over a period of time. So they would step from being an executor into the role of a pure trustee and manage a trust going forward under the will. But basically speaking, in the simplest sense, an executor stands in the shoes of the deceased person. They manage their assets and they distribute according to the terms of the will. That's the easiest way to describe that. So I'm sorry, Julian.
Oh, I was just going to say, we often hear the word probate when we think of the executor's job, and could you tell us a little bit about probate?
Yeah, probably one of the most misunderstood and feared things in the world. So perhaps the best way for me to explain what probate is would be to give an example. So let's assume that I have an investment portfolio of $250,000 with Bank of Montreal, and I die. All right, I have a will. I've named my 2 sons as executors. So my sons come to the lawyer's office. They get a notarial copy of the will, that is a copy that's been certified by the lawyer. And they walk over to Bank of Montreal and say, Bill's dead, and we're the named as state trustees. Give us the money. We want to give it to the will. And the bank says, whoa, just a minute. No. We're not prepared to turn the money over to you until we are satisfied that you are the right people to receive the money. I say, well, here's my will. Here's the will. It names the 2 of us. Here's our identification. What's wrong? And the bank says, no, we're not satisfied with that. We want your appointment as executors to be validated. So my executors say, well, how do we do that? They say, we want an order of the Superior Court in Ontario that says you are the properly appointed executors and entitled to act on behalf of the estate. So the process is that my two executors make application to the Superior Court. We do that for them. It's a court application. The will goes before a judge. They do a search throughout Ontario, make sure that it's the last will. No issues of public policy. And then the court issues what used to be called a grant of probate because it was the probate court. But now, again, it's got a fancy new name, too. It's called a Certificate of Appointment of Estate Trustee. Anyway, we still call it a grant of probate. The court order is given. My two executors take the court order and they walk over to Bank of Montreal, say to the bank, all right, here's the grant, here's the probate order or certificate, and bank looks at that and says, that's great, here's the money. So why did the bank want to make sure that my executors were validated by a court order? Because if they had given the money to anyone who wasn't validated, they'd be on the hook. So the bank is not on the hook when they're acting with probate. Similarly, if I'm buying a piece of property from an estate, I want to make sure that the executors signing the deed are properly validated by the court. So that process of validation, that's what it is. It's the court validating the estate trustees. That's probate.
Does that cost the estate any
It does.
fee?
So it's the Ontario government. A lot of people think this has to do with the federal government. It's not. Probate is a provincial thing. So when I make application to the Superior Court to get my court order, the province of Ontario says we should have a small fee going through here, and that fee is nothing on the first 50,000 of assets, but it's 1.5% on the value of all assets after that. The easy way of thinking about it is that it's 15,000 per million of value, give or take a little bit. So 15,000 is not to be sneezed at, in terms of that process. But I will tell you that the steps that are taken to avoid probate quite often end up with some of the most horrendous estate planning that you can imagine. So you might ask me, how do you avoid probate? How would you avoid probate? So probate applies, or any assets that are in my name alone will probably be subject to probate. If I put my assets with one of my sons jointly, or I designate someone as a beneficiary under a RIF or an RSP or successor holder under a TFSA, those assets are all dealt with by operation of law. They don't fall under my will. So we have two means of disposing of our assets. One's our will that deals with only my ass in my name alone. And then this whole other area where by contract I can dispose of assets, designating beneficiaries and doing that. And the favorite story I tell about doing that was a lady that called me one day, and she said, "Bill, you'll never guess what I've done." And you'd love that comment, eh? Right off the top. And I said, "No, what have you done?" And her name was Adele. And she said, I was at the bank yesterday, and the bank told me I need to avoid probate at all costs. And I said, all right, and what did you do? She said, I put all my investments in Bonnie's name with me. And I said, well, that will do it. It will keep it out of your will, and you will probably avoid probate. But I said, you have 4 children, and you've put it in Bonnie's name with you. And I said, are you sure, that you want to do this? Oh, yes. I realized that Bonnie would be the owner, but I know she'd treat everybody fairly. I said, well, that's good. And then I went down the list and I said, well, what if Bonnie had dementia? What if Bonnie had a traffic accident? What if Bonnie's business went bankrupt? What if Bonnie had a matrimonial difficulty? I went through the litany of things with her. And I said, in all of those circumstances, it would be difficult for you to maintain control of your assets, and they might be at risk. And I said, the biggest thing is that you are going to lose control. Every time you deal with those assets, you have to have Bonnie by your side. And I said, do you know how much the probate fee is? No, they didn't tell me that. And I said, well, it'd be $7,500. So between the 4 children, that's $1,500 apiece, and you don't have to write the check. So the next day she went back and changed it all back. So, and it's just, I don't mean to be, try in terms of the story, but you have to be very careful to plan that type of thinking. It's like designating 3 children on a beneficiary on an insurance policy. And unless it's done properly so that grandchildren would share if a child died under that policy, the insurance policy will go to the other 2, not the intentions that someone would have had in their will. So you have to be very careful, when you're dividing between what's managed under my will and what's managed by other means, in terms of that. Right. The other big thing about probate, people say it'll take years. Well, it doesn't. In Peterborough, for example, prior to COVID, we were getting our court orders in 4 to 6 weeks. That's how long it took. So during COVID, that got as high as 6 months,
Right.
But it's coming back. So
Right.
bit by bit.
What happens if someone dies without a will?
They're intestate. So that's the term that's used when you die without a will.
Sounds like a stomach condition.
It is. It's very much like that. It may be. So if you die intestate, then the province makes a will for you. All right. Under the Succession Law Act, there's a scheme of priority in terms of who gets what. So there's two factors. One, who's entitled to seek administration to become the estate trustee. So that's one thing. And then the second thing is, how is an estate divided in terms of money? So generally speaking, parents are first, so if I die and my parents are alive, one or more, they would be the first people entitled to apply to be my executors. If they don't want to do it, my siblings would, and on down. So there's a whole hierarchy again. And there's a hierarchy in terms of distribution. Where there's a wife or a spouse, she would get the first $350,000, and then the balance would be divided between children and the wife. If there's no children, the wife would take it all. I mean, it's all set out. So if there's no relations, it could be first cousins that take the estate, but the government won't get it.
So one other question that I think I would like to have clarified is around the role of an executor if the estate at the end, like if somebody was the executor without really knowing what he or she was getting into, and then the person dies and they discover that this person was in huge debt. Who's responsible now for that?
Well, I for one am in that position with a file of ours. I'm the executor, and have known this individual for a long time, and they've recently come upon very difficult financial circumstances that I wasn't aware of. So we have more debts than we have assets, and so what I'm doing is I'm conducting an informal proposal with the creditors, saying, this is the money we've got, these are all the debts, this is what your share would be. So I'm not personally liable.
Okay, that's what I was getting at.
I have no personal liability as an executor unless I make myself liable. So if, for example, a bank loan had to be taken out and I as the executor personally guaranteed it, I'll incur liability. But in my role as executor, okay, I'm not responsible. No.
Okay.
Yeah.
Wow.
Yeah. Jeez.
So it's all of these pieces, and it seems like easy easy to avoid this, right? It's easy to not to have to think about it until we're faced with the reality of how important planning and preparation and paying attention to these things are. But as you mentioned early on, often, these things come up in crisis, and now all of a sudden people are now having to think in this crisis mode as opposed to the conversation and the preparedness, because the reality is we're all going to die, and we're all going to be in that place with our families too. Mm-hmm. So I think this has been so helpful to have, just the beginning piece of that. Where would you suggest people start? Like, what kind of a lawyer do they look for if they want to do their wills and this work? Where do they begin that process?
And what if they can't afford a lawyer?
Right.
Because this is what I've heard from clients before when I've asked them if they have started this process. And I know, Red, you had this once before at hospice as well, where they didn't have the means, or they didn't perceive that they had the means to follow this through legally with a lawyer.
Mm-hmm. It's very interesting how little value people put on advice, and I don't mean to be harsh in saying that, but people will spend more on tire changes and oil changes on a vehicle in 1 year than they would expect to pay for legal advice to make sure their will and powers of attorney. And I'm not being. It's just a value judgment. It's just a value judgment. Complex wills can take time. They do, and they're not necessarily inexpensive. The competing factor to an experienced will and power of attorney practitioner, is the internet. People are becoming self-educated. They are taking will kits, forms, they're filling them out and relying on those documents. You'd be surprised how many times I'll get a call and people will say, I've done my own will, took the form, I want you to check it over. Well, you don't check over a document without the discussion. You can't do that. So I have to explain, I'm sorry, but I can't merely look at a document and know that it meets your requirements. So, I won't say it's a myth that people can't afford wills, because it's not. I tend to think that having wills and powers of attorney with the right people and the right thing is probably the best investment that people can make. It's hard to educate people that is a great source of comfort, and it's a great source to a following generation that, is not going to be impacted by anything I do. To give you an example, you'd be surprised how many people treat their beneficiaries differently, all of the same class. For example, 4 children. 2 of them may get nothing out of a will, or 2 may get the same, 1 may get less, and 1 gets nothing. So that in itself, when those children read that will, without explanation, they're going to say, well, why? The lawyer must have made a mistake here, which wasn't the case. But without editorial language in a will that says, so-and-so doesn't get anything in this will because I've had no meaningful relationship for more than 20 years, all right? I don't know my grandchildren. I've never met them. So I'm not making any, but excluding them is intentional. Without that language in the will, that is a disaster for those 4 children. So would you put that in a will kit, or would you know enough to put that language in a will kit? No.
Yeah. Excellent points.
So, I can't, it's what we're trained to do. It's what we do, and, yeah.
What you're speaking to me is what I'm hearing is that we have an obligation and a responsibility to leave this world as best that we can. so that there's less mess, or at least it's as clear as possibly it can be. And even with that kind of clarity, there can still be issues that come down the road. But that sense that we have an obligation, that when we leave this world, there's a duty for us to do some work in order to make that happen as smoothly as possible. And I don't think we talk about that very much in our culture and in our world, that I'm here, I'm alive, and I know I'm going to die, and I have a sense of obligation to do that well and leave my affairs in order.
Yeah, it's, if there was one goal that I had in doing my testamentary planning, it would be create no problems. Mm-hmm. As simple as that.
What a great spot to end.
That feels like an excellent
Create no problems.
Create no problems.
Create no problems. Thank you so much for sharing we can just hear the wealth of experience and expertise as you speak, and it's so informative. Thank you.
Thanks for listening to What Now on the Threshold of Life, Death, and Grief. What Now is produced in partnership with Hospice Peterborough. Music is by Paradise Garage, and technical support provided by Sean and Jonah Heichert. What Now is recorded at Thin Spaces Studios. You can find more episodes of What Now for free on most major podcast platforms, including Spotify, CastBox, Apple Podcasts, and Overcast. If you want to support us, please follow and leave a review wherever you get your podcasts, and tell your friends. It does make a difference.